the Vice Chancellor of Sastra University, Dr. Vaidya Subramaniam, Justice Kannan, who served very illustriously in our High Court of Punjab and Haryana for 8 long years, Dr. S.Y. Qureshi, for whom I have the deepest personal respect, my colleagues, Mr. Purva and Mr. Sai Deepak, distinguished ladies and gentlemen, when Dr. Vaidya Subramaniam called me to say that they were going to re-agitate the question of the Uniform Civil Code, it was the lure of getting another Veena which drew me to Chennai. Well, in his wisdom, he's decided to replace the Veena with the equally beautiful statue, so that be it. But Dr. Vaidya Subramaniam, thank you very much for giving me the chance to be here once again. And I think it just goes to show how germane this ghost or apparition is, that even after 9 years of trying to slay it, it still continues to have a life of its own. You know, Winston Churchill had once very famously remarked, those who don't change their mind don't change anything at all. But unfortunately, I've decided not to change my mind. You know, out of a religious partition of India, there were born 3 separate things: an Islamic Pakistan and 2 conflicting visions of India. A vision that believed that notwithstanding a religious partition, India should be a pluralistic, inclusive, democratic nation where it should become the umbrella where everybody, irrespective of their caste, color, creed, region, religion, will have equality of opportunity, and there would be egalitarianism, a level playing field, and an equal opportunity for everyone to be able to maximize themselves. Then there was another vision, and that vision was that if we had a partition on religious lines, then it should have gone to a logical conclusion. In other words, if there was an Islamic Pakistan, there should have been a Hindu India. Unfortunately, the province that I come from, which I have the privilege, the truncated province that I have the privilege of representing in Parliament, suffered the worst ravages of that partition. 2 million dead, 20 million rendered homeless in a span of 2 months between the July and the September of 1947. From Rawalpindi to Delhi, everything was destroyed and devastated. People who knew something called home and hearth for centuries became rootless refugees in just a matter of time. And out of that violence, which actually convulsed the birth of this nation, was born the endeavor to write the Constitution of India. And so therefore, when the Constituent Assembly met for the first time on the 9th of December 1946, and unfortunately a substantive bulk of its members withdrew by the June of 1947 to form an alternative Constituent Assembly, the remaining members tried to encapsulate that former vision of a pluralistic, inclusive, secular India into the design of the Indian Constitution. And incidentally, it's a very revealing statistic that 94.6% of those people who sat in that Constituent Assembly were actually Hindus by faith that they professed. So therefore, you had a Constituent Assembly which was dominated by people of a particular faith after a religious partition which convulsed the soul of the nation, and what they engrafted was the vision of a pluralistic and inclusive India. And therefore, the Constitution of India is not a legal document. The Constitution of India is a political document which really embodies the hopes and aspirations, the desires and dreams, and the vision of an entire nation which was looking at a new tomorrow. And that period between the June of 1947 and the 26th of November 1949 was when some of the finest minds met, not to eradicate monuments which had been built by the British and build alternative monuments in turn, but actually design a document for posterity. And in their wisdom, they actually drew out a constitution which was carved out in various parts. There were certain parts of it which were non-negotiable. Part 3, which dealt with fundamental rights, and Part 4 and Part 4A, which were declaratory in character, which were non-binding. And therefore, when you read the directive principles of state policy, Article 37, which actually inaugurates that particular chapter, is very, very illustrative in what it says. And it says that the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making the law. So, essentially, the directive principles of state policy were a set of principles which they were setting forth, which the framers of the Constitution, the founders of the modern Indian Republic, thought must be intrinsic to the various laws which would be made by Parliament and the legislatures over a period of time. And it is interesting that the directive principles of state policy have 18 articles. And it's ironic that out of those 18 articles, some of them which are of seminal importance, 39A, 42, the only one which seems to find resonance is Article 44. And I often wonder as to why Article 44 has become the dog whistle of the directive principles of state policy. And interestingly, if you read the words of Article 44, and Mr. Qureshi had read them out just a while before, but I would take the liberty of reading them out again. It says the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The words are the state shall endeavor. It is not that the state shall enforce. And when you talk about a uniform civil code, you're not talking about a common civil code. There is a marked distinction between a uniform civil code and a common civil code. And the distinction is that a uniform civil code is essentially that there would be certain underlying principles which would promote equality and egalitarianism within the panoply of various personal laws which predates the Constitution of India by centuries and millennia. So therefore, when the Constitution was being written, the Constitution framers were very, very conscious of the fact that in a deeply religious and secular country, a deeply religious and spiritual country, they were trying to inculcate a constitutional design whereby they were deliberately separating the church from the state. And so therefore, while the word secular finds mention in the preamble of the Constitution only in 1974, the design of the Constitution, the fundamental constitutional design, was encapsulated that pluralistic vision which they wanted, or they wanted what India should be. And that's why when you read Dr. Ambedkar, when he defended Article 44, even Dr. Ambedkar in his defense was extremely conscious of the fact that he was not seeking to enforce a uniform civil code. In fact, if I may read out what Dr. Ambedkar said, and I quote, "I quite realize their feelings in the matter, but I think they have read rather too much into Article 35, which merely proposes that the state shall endeavor to secure a civil code for the citizens of the country. It does not say that after the code is framed, the state shall enforce it upon all citizens merely because they are citizens. It is perfectly possible that a future parliament may make a provision by way of making a beginning that the code shall apply only to those who make a declaration that they are prepared to be bound by it, so that in its initial stage the application of the code may be purely voluntary. Parliament may feel the ground by some such method." So even when the directive principles of state policy accepted Article 44, the intent of the framers of the Constitution was that it would be purely voluntary in character. And so therefore, the Uniform Civil Code is really a shorthand for laws that govern marriage, divorce, inheritance, maintenance, guardianship, adoption, and succession. And that's why, and that's the reason why I say that the Constitution is a political document. Because when we structured the federal scheme to incorporate Nagaland or to integrate Nagaland into India, we made an explicit constitutional declaration that Naga personal laws will not be touched. We did the same with Sikkim, Article 371F. We did the same with Mizoram in 1986 after the Mizoram Accord was signed. Gave protection to their personal laws because those personal laws, beliefs and customs were of extreme importance to them. And the government of the day found it necessary to give that protection by incorporating it into the Constitution. Judge, I'll just take 2 minutes. And the same was done with the tribes of India. The 6th schedule, clause 25, 6th schedule for Mizoram, Tripura, Nagaland, whereby district councils were given the right to adjudicate on personal laws. So therefore, to conclude, nobody is against progressive changes which make personal laws egalitarian. Nobody is opposed to reform in personal law. In fact, when the UPA government was in office, a government which I had the privilege of serving as a minister, we brought in laws against domestic violence. We brought in laws in order to give equal rights in succession and inheritance to women. We brought in laws which ensured that child marriage was prohibited, that parents and elders were protected, and their maintenance was taken care of. So therefore, to conclude that if tomorrow there is reform in personal laws with consultation with the community, which brings about equality for women insofar as divorce is concerned, insofar as inheritance and succession of male and female children are concerned, a common age for marriage across all laws, a provision for registration of marriage. I don't think anybody has a quibble with that. But that is uniformity of principles and not a common civil code. So therefore, while no one is opposed to a certain uniformity in principles, but given the very unique diversity of India, I think any attempt to try and impose a common civil code would actually militate against the genius of India. It would actually impact India's security, stability, and our ability to be able to punch to our weight as a cohesive entity. And I'll end with that. Thank you very much.